The time is now approximately 11:28 a.m. We are now going back on the record.
Mr. Martin, during the break, I provided your attorney with a copy of your answers to interrogatories, and do you have that copy in front of you now?
I do.
Right. I'd like to call your attention to interrogatory number 13.
We can't see Mr. Martin, excuse me.
Sorry.
Now, that interrogatory refers to paragraph 46F of your complaint, which I've previously questioned you about. And in that interrogatory, we asked, identify all individuals who have knowledge or information related to your claim that the statements at issue have interfered with your personal, professional, and family life, as you allege in paragraph 46F of your complaint. For each individual identified, please set forth the name and address of the individual, a brief summary of the knowledge or information retained by that individual, and the date and time the knowledge or information was communicated to you. And the response was, plaintiff and plaintiff's wife have such knowledge. That's what you indicated at that time?
Correct.
And then you continue, plaintiff is not specifically aware of anyone else at this time. Plaintiff's investigation is continuing, and plaintiff reserves the right to supplement this response. Okay,
You read it correctly. I'm sorry. Go ahead.
Yes, and I've read that correctly.
Yes.
And I'm asking you now, can you supplement that response at this time?
No.
Going back to your complaint, there is an introductory paragraph. It's labeled Introduction. And although it's not part of the numbered paragraphs, it contains some allegations and claims against my client relating to the WAEB AM 790 interviews, my client's internet blog and Facebook site. When you signed the verification to this complaint, were you also verifying the statements in that introduction?
Yes.
And in the concluding paragraph to that introduction, you state, these statements were broadcast on the radio and continue to be accessible through the internet. And the radio that you're referring to is the Bobby Gunther Walsh radio show on WAEB AM 790 from February 20th, 2014 to August 4th, 2014, and on my client's internet blog and Facebook site.
Correct.
And continuing from February 20th, 2014 to the present. So the time period that you're describing there is the time period beginning with the WAEB interviews, correct?
Yeah, with the qualification that where it says continuing to the present is up to the date of the filing of this complaint.
Okay, all right.
Yeah, at that time.
At that-
I'll allege that they have continued even to today.
All right. But the time period you're referring there to in the introduction is from February 20th, 2014, up to the time of filing the complaint.
Correct.
When did you first become aware of the WAEB interviews?
The first day they were broadcast
And how did you become aware?
through Mr. Villa's blog and the fact that he was making statements that he would soon appear on the Bobby Gunther Walsh show.
As a so that was prior to the actual interviews?
Yes.
So you were aware that he was going to be on the radio?
I was aware that he was claiming that he was going to be on the radio.
And did you listen into the WAEB interview on February 20th, 2014?
Yes,
And where were you when you listened to that interview?
in my car.
So you heard the interview before anybody else told you about it?
Yeah, I think so.
And you were in your car going where?
Well, I was on my way into the office, but I stopped, I believe, at the Sunrise Diner on South 4th Street in Allentown and listened. The first broadcast was, I think, about 10 minutes, 12 minutes in duration. I believe I listened to it in my vehicle while it was parked in the parking lot.
And did you listen to the entire interview?
I believe so.
And what did you do after you concluded listening to that interview?
I went in and had breakfast.
You had breakfast alone, or did you meet anyone there?
I don't recall specifically, but usually I would sit at the counter and there would be people who I've come to know over the years who typically eat breakfast in the same diner at the same counter as I do.
Do you remember the names of those people?
I remember specifically Danny Surface, and I know names of other people. I don't recall people that day.
When you were there that day, was there any discussion about the WAEB interview that you had just heard?
I don't think so, not that I recall.
And who is Danny Surface?
Danny Surface was a gentleman who used to eat breakfast at the diner. Unfortunately, he is now deceased.
And you had no conversation with him about the WAEB interview?
I don't believe I had conversation with him on that day. I had conversation with him subsequently where he told me that he had heard the WAEB interviews on a number of different occasions.
And what did he say about those interviews?
They're really beating you up on WAEB.
Anything else?
Well, yeah, he mentioned Bobby Gunther Walsh. He mentioned Bill Villa. He mentioned some of the things that were said.
Did he indicate he knew Bill Villa?
Did he know Bill Villa?
Yeah.
Not to my knowledge.
And after you finished breakfast that morning, where'd you go?
My office.
And when you arrived at your office, did you have any discussions with anyone about the WAEB interview you had just heard?
Not that I recall.
When was the first time you had any conversation with anyone else about the WAEB interview?
I don't recall.
Was it that day?
I don't recall.
Did there come a time when you did have conversations with others about the
I am
interviews?
certain that I had conversations with other people about a whole series of these interviews, but I don't recall specific dates, times, places.
Or with whom?
In some instances, I recall with whom, yeah.
Okay, with whom?
I believe I mentioned in answer to interrogatories, Roger McLean, who's a former chief of police in Allentown and now chief criminal investigator employed by the county of Lehigh at the Regional Intelligence and Investigation Center, essentially works for me. I've had conversations with Gene Bucknow, who recently died, his wife Marcia Bucknow, my wife, other co-workers from time to time, but I can't recall specifically whom.
All right. Tell me about those conversations that you do recall, with whom and what was said.
Mr. Shea, I can't recall specifically what was said. I can give you the tenor of the conversations, which is I recall and understand them to be they were recounting the fact that, in the opinion of the people who were talking to me, Mr. Villa was unfairly attacking me and criticizing my performance. He was lying about me.
So the only conversations you recall were conversations that were supportive of you?
Yeah, I don't recall any conversation that was supportive of Mr. Villa other than, some comments I may have read, and not conversation, but comments I've read on his blog.
The Bobby Gunther Walsh show, can you describe that for me? What type of show? What was the format?
It's a morning drive talk show, typically presided over by Bobby Gunther Walsh for a very long time. I can't tell you how long, but I would guess 20 years or longer.
Was that something you listened to regularly?
No.
Was it something you listened to occasionally?
Yeah.
And would you describe the tenor of that show being conservative or liberal, moderate, based upon your listening to the show?
It was a talk show. It covered a gamut of things. I would guess it would be considered, or Bobby Gunther Walsh at least would be considered conservative in his political views.
To your knowledge, had Bobby Gunther Walsh on his show or any guest on his show prior to the Villa interviews been critical of you and your performance as district attorney?
Not that I'm aware of.
Were you aware if Bobby Gunther Walsh or anyone who was on his show before the Villa interviews expressed support for you or being supportive of you?
Not that I'm aware of.
In paragraph in the complaint, in paragraph 22, and I believe I previously questioned you about this, you describe the specific criminal prosecutions and your management of prosecutions in Lehigh County, which Mr. Villa was critical of. Is that correct?
Yes.
And I'm going to be going over these prosecutions in more detail a little later. But Robert LaBar, that was the prosecution of the driver of the vehicle in which Sheena Villa was a passenger, and involving the crash that she died from. Is that correct?
Yes.
And in that particular prosecution, Mr. Villa urged you to charge Mr. LaBar with third-degree murder. Is that correct?
Yes.
You refused.
I did not charge third-degree murder.
Right. You didn't grant his request.
Correct.
And you charged Mr. LaBar with what?
He was charged with homicide by vehicle while DUI, involuntary manslaughter, recklessly endangering another person or persons.
Now, I'm going to refer, for purposes of convenience, to the class of cases Mr. Villa was critical of as DUI homicide cases. Any problem with that?
Yeah, because they were not charged as such in some instances.
Okay. And in those instances, and we'll get to those in a little while, those were instances where Mr. Villa felt the defendant should have been charged with DUI homicide.
I think that's a fair statement as to Mr. Villa's feelings.
Okay. So in the LaBar case, Mr. Villa felt that the man who killed his daughter should be charged with third-degree murder, and you charged him with lesser offenses than that, correct?
Correct.
With regard to Chris Squires, Mr. Villa felt that he should be charged with DUI homicide, correct?
He was.
Was. And what happened to that?
On the eve of trial, some issues arose, which in the judgment of the attorney who was handling the prosecution, felt would have been an impediment to conviction, and a plea agreement was worked out where Mr. Squires, as I recall, pled guilty to homicide by vehicle and some other charges. I don't recall the specifics. He did not plead guilty, and he did not, although a jury was selected, he did not go to trial on the charge of homicide by vehicle while DUI.
Right. So a plea bargain was arranged whereby that charge was dropped, correct?
We prefer to refer to it as a plea agreement.
As a plea agreement. But in any event, the most serious charge, the DUI homicide, was dropped, correct?
It was dropped because we did not feel at that point that we had evidence sufficient to convince a jury to find him guilty beyond a reasonable doubt.
All right, and I understand that. We'll get into that in a little while. But the fact of the matter is, Mr. Villa felt, and expressed it in the WAEB interviews, that the DA's office should have followed through with the DUI homicide charge rather than the lesser charges in the plea bargain.
Mr. Villa accused me of showing favoritism in that case because of the result that he was not tried on the charge of homicide by vehicle while DUI, because he contended I had a long-standing friendship with Chris Squires' grandfather, Ned Squires, which is inaccurate, by the way.
All right, well, we'll get to that in a little while. But getting back to my question, in this particular case, Mr. Villa was criticizing your office for dropping the DUI homicide charge and having a plea agreement for lesser charge or charges, correct?
He was criticizing me.
Right. But he was also criticizing your office, correct?
Correct.
Right. Now, the Amber Washko case, that was a case where Mr. Villa felt that she should have been charged with and prosecuted for DUI homicide, correct?
I assume that that's correct, Mr. Shea, based on Mr. Villa's statements. I don't know what's in his mind, okay?
Okay, so you don't know what was in his mind.
I don't know what was in his mind. I know what he said.
All right, well, let's talk about what he said.
Okay.
All right. With Amber Washko, he felt that and expressed that in the WAEB interviews that your office should have prosecuted her for DUI homicide, correct?
Correct.
And did your office follow through with a prosecution on that?
There was no evidence to support such a prosecution.
And what was she charged with?
She was charged with DUI.
Now, the accident that she was involved in did result or involve the death of someone else, correct?
Joseph Hennessy, yes.
Right. So again, Mr. Villa was criticizing your office for not charging Amber Washko with DUI homicide, correct?
The correct term is homicide by vehicle while DUI.
Okay. I mean, was that what you would prefer me to use?
Yes. I'd like to be precise.
I can appreciate that. Homicide by
By
vehicle
vehicle while DUI,
while DUI.
specifically while driving under the influence.
Right. Can I use DUI rather
Yes,
than driving
you
there? Right. Okay. So in the Washko case, Mr. Villa felt that Amber Washko should have been charged with homicide by vehicle while DUI.
Mr. Shea, I don't want to quarrel with you, but I don't know what Mr. Villa felt. I know what he said, okay? Without understanding, the answer is yes.
Right. And she wasn't charged with that.
She was not. She was charged with DUI.
And what happened to that charge?
She pled guilty.
Jennifer Geringer also mentioned in paragraph 22, her case.
I believe it's pronounced Geringer, but
Geringer? Okay.
she was likewise charged with DUI. In that case, a man by the name of John Togus was killed as a result of a vehicular crash. He was a pedestrian.
Involving a vehicle operated by Jennifer Geringer.
Correct.
And again, during the WAEB interviews, Mr. Villa expressed his belief that she should have been charged with homicide by vehicle while DUI.
Correct.
She was not charged with that.
Correct.
What was she charged with?
I believe I just answered that, DUI. Driving under the influence.
Did she plead guilty to that?
Yes.
Now, in all of the cases that I've just mentioned, Mr. Villa objected to those criminal defendants not being charged with the exception of Robert Labar, homicide by vehicle while DUI, and following through on those prosecutions, correct?
Well, as I stated earlier, Mr. Squires was in fact charged with homicide by vehicle while DUI. Because of matters of proof and evidence, that charge was withdrawn and he pled guilty to homicide by vehicle. You are correct that Amber Washko and Jennifer Geringer were not charged with homicide by vehicle while DUI. Mr. Labar was, of course. The paragraph also refers to a James Lauer. I don't know whether you are including that in your question or not.
Yeah, James Lauer, and I'll get to that later, his matter involved a furlough while he was in prison, correct?
That's one matter that Mr. Villa complained about, yes,
Right.
in connection with Mr. Lauer.
Any other things he complained about with regard to Mr. Lauer?
Well, several years after the furlough, Mr. Lauer was involved in a DUI related crash that did not result in any deaths, fortunately, but resulted in injuries. As I recall, he had crashed into a van carrying a father and several children in the vicinity of the Muhlenberg Elementary School in Allentown, generally in the vicinity of 21st and Tillman Streets.
Right. That was not the subject of your complaint because that had not yet happened, is that correct?
No, that happened in 2014. You asked me what Mr. Villa was complaining about, and in addition, the furlough complaint was raised in the context of, as I recall, Mr. Lauer's crash in January of 2014, which would have preceded the radio broadcast.
Now, after that initial broadcast with WAEB, did you listen to any more of Mr. Villa's interviews on the
Yes.
station? How many more?
I think all of them.
Now, in your complaint, you acknowledge that your office in 2006, 2007 prosecuted and obtained a guilty plea from Robert Labar to homicide by vehicle DUI.
Are we on a paragraph?
Paragraph 15. Inter alia, as a result of Labar's criminal conduct in causing the death of Sheena Villa. When did you first become personally involved with the investigation and prosecution of that case?
Well, first of all, the district attorney's office is not an investigating agency, okay? So if you want to use the word investigating, please understand that that's my context. I know that the media frequently refers to my office as investigating matters, and in some discrete instances we do, but I was never really involved in the, quote, investigation of that accident. That's done by the police department. But I first, to answer your question, I think, as best I can, I became aware of the fact that there was an investigation being conducted by the Allentown Police Department, which was likely to ripen into a criminal prosecution, when I received an email from Mr. Villa at my office late in April of 2006, accusing me of showing favoritism for not having filed charges against Mr. LeBar within the 5 weeks from the happening of the vehicular crash that unfortunately killed his daughter.
All right, so up until that point, you had had no involvement with the case.
That's correct.
And what was the date of death of Mr. Villa's daughter, Sheena?
My recollection is that the crash occurred in the early morning hours of March 24, 2006.
And when was this? You got the email from Mr. Villa?
It was late in April of 2006, and I don't recall the specific date, but one of the allegations in the email was that it was now 5 weeks past the date of the crash, and why haven't charges been brought against Mr. LeBar?
Did you respond to that email?
I think I did, yeah.
Did you respond by email or by telephone?
I don't recall. I think I responded by email.
Now, at the time of that tragic occurrence which led to the death of Sheena Villa, did you know Mr. Villa?
No.
Were you aware of any criticisms that he had made about your performance of duties as a district attorney before his daughter's tragic death?
No.
As a consequence of getting that email from Mr. Villa, did you speak to anyone about him or try to find out who he is or was?
Yes.
To whom did you speak?
Renee Smith, who's the Chief Deputy District Attorney in my office, who heads the division that prosecutes driving under the influence cases and homicide by vehicle while DUI.
And what was your conversation with her?
I asked her what it was about.
And was she involved in that prosecution at that time?
She was knowledgeable about the case.
And did she indicate that Mr. Villa had any prior communication with her?
I don't recall her indicating that.
When was your next communication with Mr. Villa following that email he sent to you?
I had a personal meeting with Mr. Villa in my office sometime during the summer of 2006, after we filed the charges. I don't recall the precise date.
Did he request that meeting, or did you request to meet him?
He requested that meeting through a person who worked in the area of victim witness in my office, I think for Crime Victims Council of Lehigh Valley.
Do you recall the name of that person?
I don't.
Right.
I know it was a male. I know he was Latino. I'm sorry. He left the office shortly after that. He was never employed by me. He was employed by Crime Victims Council.
Did you have any conversation with that person before your meeting with Mr. Villa?
Yeah, he indicated that he had been in touch with Mr. Villa, or Mr. Villa rather had been in touch with him and had expressed a desire to meet with me, and I granted that request.
That took place at your office at the Lehigh County Courthouse?
Yes. With this qualification, the office in 2006 was on the 4th floor of the old building. My office since 2009, 2010 has been on the 3rd floor of an addition to the Lehigh County Courthouse.
And was anyone else at that meeting besides you and Mr. Villa?
I believe for a short period of time the representative of Crime Victims Council was there, but I think he left at some point.
Did you record that meeting with Mr. Villa?
No.
Did you take any contemporaneous notes?
No.
Did you make any notes after the meeting?
No.
Did you report to anyone else about the meeting with Mr. Villa?
Did I report to anyone else?
Yes.
If you mean did I mention it to someone else, I probably talked with Renee Smith about it. Yeah.
And what was the conversation between you and Renee Smith after your meeting with Mr. Villa?
I don't recall. I'm sure, given the fact that she was in charge of the prosecution of the case, that at least at that time, that I would have mentioned to her that I met with Mr. Villa. I probably mentioned that he was unhappy that we weren't charging murder 3 because that was the main topic of the meeting. He asked me, I recall that he asked me what my estimation was of how much time Mr. Labar could receive on the charges that he was facing. I believe I indicated to him that under a statutory construction he could get as many as 19 years. He indicated to me that he knew he wouldn't get that much time, and what was my best estimate of the time that he would receive. I think my estimate at that time was 4 to 4.5 years. I was off by a year and a half.
And what was Mr. Villa's reaction to that when you said 4.5 years?
I think Mr. Villa was okay with that. He didn't express any surprise.
During the course of that meeting, did the subject of charging Mr. Labar with murder of the 3rd degree come up?
Yes.
Tell me what you recall about that conversation.
I recall that Mr. Villa wanted us to charge murder of the 3rd degree. I recall telling him that, in my opinion, that was inappropriate and telling him why it was inappropriate.
What was his reaction?
I don't think he was pleased, but, you know.
Did he express his displeasure?
I'm sure he did, yeah.
How did he express his displeasure?
Yeah. Said he didn't agree with it.
Did he present you with any case law or case citations to support his claim that Mr. Labar should be charged with murder in the 3rd degree?
Not on that occasion that I recall. I know subsequently he sent an email. I believe he directed it to Renee Smith and myself, or perhaps to Richard Director, who by that time was heading the prosecution. I think he cited 4 or 5 cases where, in his view, they were similar to the crash involving his daughter, and that murder of the 3rd degree was charged in those cases.
Did you or any member of your staff at your direction do any research to see whether there was case law supporting a charge of murder in the 3rd degree?
I think we looked at, I remember looking at a case called Commonwealth versus Levine, which was a Philadelphia case. I don't recall whether I personally looked at any of the others. I'm satisfied, Mr. Shea, that those cases were an exception rather than a rule.
Based on what?
Based on the laws, I understand it and know it.
Now, Mr. Villa has brought to your attention other district attorneys who have charged defendants with murder in the 3rd degree involving driving under the influence resulting in a homicide. Did he not?
Mr. Villa on his blog has pointed out cases that I think were brought in Bucks County charging murder of the 3rd degree. I recall, I believe, an email early on in the progress of the case involving Mr. Labar where he mentioned a lawyer or a district attorney from north central Pennsylvania by the name of Jeff Lieber, who brought a charge, or had, Mr. Villa had some correspondence or some conversation with Mr. Lieber, at least as he related it.
As a result of your discussions with Mr. Villa and his request that Mr. Labar be charged with murder in the 3rd degree, did you consult any other district attorneys from other counties who have filed that charge?
No.
And why didn't you charge Mr. Labar with murder in the 3rd degree?
Because driving under the influence, or homicide by vehicle while driving under the influence, the driving under the influence aspect of that is not a per se violation. It's not a strict liability crime. You have to show gross negligence, you have to show that the person you're accusing has disregarded a great and justifiable risk that his conduct will or could result in death or serious bodily injury. And there are many, many cases where the courts in Commonwealth of Pennsylvania have found that merely driving while intoxicated is not sufficient proof to show homicide by vehicle while DUI. You have to show gross negligence. You have to show what I just indicated. And in fact, there's one case, Mr. Shea, with which I'm familiar, that in the context of this particular factual situation, a court has stated, probably in dicta, that a driver in the position of Mr. Labar would essentially have to have a death wish himself because his conduct as a driver is putting him in danger of, would have to put himself in imminent danger of death or serious bodily injury. And therefore, malice is not present.
Mr. Villa contended that malice was present.
Yes.
He cited the speed of Mr. Labar's vehicle, correct? He also cited the fact that there was evidence that his daughter was screaming for Mr. Labar to slow down, correct?
Mr. Villa said that. Subsequent investigation did not bear that out.
And what was that subsequent investigation?
Interrogating Sebastian Gubitosi.
And what did that interview with Sebastian Gubitosi indicate?
Mr. Gubitosi, I did not interview him, so what I'm relating to you is something that was told to me by someone else in my office, Richard Director. Mr. Gubitosi indicated to Mr. Director that Mr. Labar was driving okay until he pulled off of Cedar Crest Boulevard and proceeded on initially what would be the extension of Linden Street in Allentown, but turns into Parkway Boulevard, which is where the crash occurred, that during the progress from that point at Cedar Crest Boulevard to the point of impact, which after I learned this, I instructed Mr. Director to ask the accident reconstructionist how much time would have elapsed. My recollection is that we were told it would have taken approximately 13 seconds to traverse that distance from Cedar Crest Boulevard to the point of impact. My recollection is that Mr. Gubitosi indicated that he was driving okay even after he turned off of Cedar Crest Boulevard, but there was a discussion between the three occupants, meaning Gubitosi, Sheena Villa, and Mr. Labar, about going to Mr. Labar's home, and that Sheena told Mr. Labar to slow down. There was never any indication, at least by Mr. Gubitosi, or at least told to me by Mr. Director, that there was any screaming involved. That's Mr. Villa's characterization.
All right, if I may just diverge here for a moment. One of the issues in this case has been discovery of information from the District Attorney's Office under CREA.
Correct.
And what is CREA?
Criminal History Record Information Act.
The information that you've just given me by your office's investigation with Mr. Gubitosi, I was under the impression that neither you nor your office would divulge that information because it's protected by CREA.
I cannot disseminate any written material or investigative reports, but I think I can testify in answer to your question, my knowledge.
Okay, all right, well, we'll sort that out because...
Well, let's go off the record for a second and have a discussion.
The time is now approximately 12:08 p.m. We are now going off the record. The time is now approximately 12:15 p.m. We are now going back on the record.
You've already alluded to an accident reconstruction that was done as a result of the Labar criminal charges. Was that accident reconstruction put in writing?
Yes,
Was a copy of that ever provided to Mr. Villa?
I don't know. Probably not. It would be violative of CREA to do so.
Has a copy of that accident reconstruction report been provided, to your knowledge, in responses to discovery requests by both me and the counsel for WAEB before the settlement?
No, it is not, because it would be violative of CREA to provide or to secondarily disseminate investigatory information.
What speed was Mr. Labar's vehicle traveling at the time of impact?
Mr. Shea, I'll answer the question with the understanding that in doing so, I am not waiving CREA. I mean, look, obviously, facts that are involved in a charging decision by me or by a subordinate in my office contain information that is the product of investigation. If it is something that I rely upon in reaching a charging decision, typically that would be included in the record papers. As I sit here, I don't know whether the speed that was calculated was included, but with the understanding that I'm not waiving CREA, I'll answer your question if you agree that it is not a waiver of CREA.
With regard to this specific question, the speed at which the vehicle was going, I will agree it's not a waiver of CREA.
My understanding is the vehicle was going, or believed to be going, 84 miles per hour.
Now, is the speed at which a vehicle is going a factor in determining gross negligence?
Not necessarily, no.
Not necessarily a factor, but it can be a factor.
It could be a factor, yeah.
Was there any other indication of gross negligence on the part of Mr. Labar based upon your review of this case?
When you say, was there any other evidence of gross negligence, I'm not conceding that merely driving 84 miles per hour is gross negligence. There is case law that supports that.
What about a defendant who is a blackout, for lack of a better term, a blackout drunk? Is that a factor?
It could be a factor in determining gross negligence, sure.
Did you make any determination whether Mr. Labar was a blackout drunk?
No, Mr. Labar never waived his Fifth Amendment privileges. He never discussed any of the facts of the accident prior to his pleading guilty.
Okay, how about during the guilty plea hearing?
I think during either the guilty plea or the sentencing, in response to a question from the judge, he acknowledged that he had a drinking problem and that he blacked out on occasion. I don't think he said that he blacked out on this occasion.
All right. Were you present for the guilty plea hearing?
No.
All right. But there's a transcript of that guilty plea hearing?
I would believe there is, yeah.
Right. And do you have access to that?
I would, sure. So would you.
So Mr. Villa was encouraging you forcefully, you would agree with that, to charge Mr. Labar with third-degree murder.
Yes,
You advised him that you were not going to do that.
correct.
And when you told Mr. Villa that, what was the tenor of the conversation at that point? Were voices raised or accusations made? Were gestures made? Anything that you recall about that?
I don't recall any of that.
One of Mr. Villa's complaint about the prosecution of Mr. Labar was that he was permitted, after the accident, to take a vacation, to travel to Belize. Were you aware of that?
I am aware that he traveled to Belize, or to some place on vacation. I shouldn't say I'm aware it was Belize. I'm aware that Mr. Villa was unhappy about that, but to say that it was permitted, wasn't permitted by me.
Whoever permitted it.
Nobody permitted it. He was on bail.
Right.
There were no restrictions on his travel.
Did your office ask for any restrictions on his travel?
No. And typically, we would not.
Right. So when Mr. Villa said that Mr. Labar went to Belize for a vacation, that's a true statement.
I don't know that of my own knowledge. I know that Mr. Villa said it.
You don't know that of your own knowledge?
How would I know whether Mr. Labar went to Belize, Mr. Shea? I don't know that.
How was it brought to your attention?
By Mr. Villa.
And did you investigate that claim by Mr. Villa?
No.
All right, so you can't refute his claim that Mr. Labar went to Belize on a vacation while these charges were
I'm
pending.
not refuting it. You're asking me if I know it, and the answer to that question is no, I don't know it.
Okay, so you cannot refute his statement that that happened.
I cannot refute that that happened.
Okay.
And in fact, I believe that it did happen. But I don't know that it happened.
The plea bargain hearing for Mr. Labar, when did that
Plea
take?
agreement, and there was no hearing.
Plea agreement. When did that take place?
I believe there were ongoing negotiations between Mr. Director and Mr. Lauer, who was representing Mr. Labar. And it would have been at some point there was a trial date set for February, I believe February 12th of 2007. So leading up to that date, if I can finish my answer,
Sure.
leading up to that date, there would have been discussions about a plea.
And those discussions took place between Mr. Director, the Assistant District Attorney, and Mr. Philip Lauer, the attorney for Mr. Labar.
Correct.
Were you involved in those plea agreement arrangements?
No.
Was your approval and consent to that plea agreement required?
Mr. Shea, I give my assistants a great deal of latitude in constructing plea agreements, but in a high-profile case such as this, I am sure that Mr. Director would have consulted with me about the plea. But in point of fact, the plea agreement consisted only of dropping some summary offenses or an offense that would have merged into the homicide by vehicle while DUI for sentencing purposes.
Right. Do you have any specific recollection of your involvement in that plea agreement before it was presented to the court?
I'm not saying that I was involved in the plea agreement. What I'm saying is that I believe with certainty that Mr. Director would have informed me of the discussions and the fact that a plea was likely to take place and would have discussed with me whether any charges were being withdrawn. But I don't recall the specifics, no.
Was Mr. Director required to have your consent and approval before making that agreement with Mr. Labar's defense attorney?
Probably not, given that only summary offenses and lesser included offenses were being withdrawn. I would not have objected to that.
Now, at the time of these discussions about the plea agreement, you were already aware that Mr. Villa was requesting a third-degree murder charge, correct?
Mr. Villa consistently requested that I charge third-degree murder from the point of his early involvement in the progress of this case. Throughout the course of the proceedings, he inaugurated and organized a letter-writing campaign to both me and to Judge Steinberg and to Renee Smith and to Richard Director. So yeah, I knew that.
So, to answer my question, you were aware at the time the plea agreement was being discussed that Mr. Villa had requested your office to charge third-degree murder.
Mr. Villa requested that I charge third-degree murder before the charges were brought. As I recall, the charges were brought in May of 2006. So yeah, I was aware of it back throughout the entire time. But that has no impact on The charges, once they were filed, were filed.
At any time before the plea agreement was finalized, did you or anyone else to your knowledge consult with Mr. Villa and any member of his family about their position on the plea agreement?
I believe Mr. Director consulted with Mr. Villa and I think the mother of Sheena Villa, Barbara. I believe her name is Macara. I think that Mr. Villa continued to voice displeasure with it. Not so much on the plea agreement as it finally was structured, but on the fact that murder 3 was not charged.
Okay, when you say you believe that Mr. Director spoke with Mr. Villa and I think you said Sheena's mother about the plea agreement, upon what you base that belief?
Mr. Director's statements to me,
And what did Mr. Director state to you?
that he discussed it with the family.
How many times did he discuss it?
I don't know.
Did he indicate whether the family was on board with that plea agreement?
I believe he indicated that Mr. Villa was still unhappy with the fact that Mr. Labar had not been charged with murder 3.
Was Mr. Villa or any other member of his family advised of the plea agreement court date in advance?
I don't know what you mean by plea agreement court case. Do you mean that, was he advised of the fact that a guilty plea was going to be entered?
Well, he was advised that a guilty plea, because you just said that's what Mr. Director said. Did you not?
You asked me about a plea agreement, and I answered that question. Now you're asking me about using a term that is not familiar to me in
Okay.
the context of criminal law.
All right. The court date where the plea agreement was presented to the judge. Okay. Was Mr. Villa and or any member of his family advised of that court date?
Yes.
When, how, and by whom?
I don't know. I mean, my office, but I believe by Mr. Director.
Is there anything in writing to Mr. Villa and any member of his family about that court date for approval of the plea agreement?
I don't know.
Have you checked?
No, not specifically for that. I mean, I think Mr. Director indicated that he was in frequent contact with Mr. Villa via telephone.
Is Mr. Director still a member of the district attorney staff?
Yes. He's part-time. And has been for the last 23 years, I think.
Now, in any event, regardless of how he was notified, Mr. Villa did appear for that court date, did he not?
It's my understanding that he was in court when Mr. Labar tendered his guilty plea.
And I may have asked you this before, but were you present for that proceeding?
No.
Did any member of your staff advise you after that court proceeding about what happened at the court proceeding?
Mr. Director did, yeah.
What did he tell you?
I don't recall specifically what he told me, Mr. Shea. I know that he indicated that the plea was taken by Judge Steinberg. I know he indicated that Mr. Villa was there, that Mr. Villa made some statement, that Judge Steinberg advised him that he would have an opportunity to do that at the time of sentencing. I don't recall anything else, but generally that's what was said.
Were you present for sentencing?
No.
And when did sentencing take place?
I believe sometime in April of 2007. I don't recall the date.
And who on behalf of your staff was present for sentencing?
Well, certainly Mr. Director. I don't know whether anybody else was in the courtroom at the time.
Do you know if Mr. Villa was present for sentencing?
Yes, he was.
How did he find out about the sentencing hearing or sentencing court date?
I don't know how he found out. We would typically send notice. Mr. Director would have told him.
And do you have any written verification of that notice?
I don't think so.
And I probably asked you this before. Do you have any written verification of the notice of the court date involving the plea agreement?
I recall, and I only recall it because it was part of a small packet of documents that it is my understanding Judge Miller's clerk released without an order. But there is a notation, I believe it's under the date of January the 18th, where an order came down or a direction came down setting a date, which I think was mistakenly characterized as a sentencing date because it was January 18 of 2007. And I believe I wrote a note in my hand to Marge Smith, who was then the office manager, suggesting that I wanted to speak with Mr. Director before the typical notice was sent out. And I wanted to make sure that Mr. Director, A, was aware of what had come from court administration or the clerk's office, and that Mr. Villa and his family were aware of it.
And how do you know they were aware of it?
Well, as I indicated before, I think Mr. Director told me that he had been in contact with Mr. Villa.
This note that you've just been describing, do you still have that, or does anyone else have that?
You have it.
We do.
You do.
Okay.
It was part of the packet of documents. I just noticed it a week or so ago in preparing for these depositions.
And that's your handwritten note?
There was a I believe, typed note from Marge Smith, which I wrote a handwritten note on and gave back to Marge Smith, because she was asking me whether the typical notice should go out at that time. And I know that the document seemed to indicate that a sentencing date was set, and I knew that that was incorrect because there hadn't yet been a guilty plea. So I said I wanted to check with Mr. Director before anything went out. I didn't want the office to notify Mr. Villa that there was a sentencing date set when there wasn't yet a plea entered.
Do you know of your own personal knowledge whether a notice of the plea arrangement court date was sent to Mr. Villa and or any other family member, of your own personal knowledge?
With this correction, plea arrangement court date means nothing to me, all right? We would refer to it, and anybody who practices criminal law would refer to it as a guilty plea date,
Okay.
okay? With that understanding, no, I don't know of my own personal knowledge.
Now, in paragraph 19 of your complaint, you say from 2006 to the present, Villa has held a personal animus towards Martin.
Mm-hmm.
What do you mean by that?
I mean that Mr. Villa, for no good reason that I can ascertain, doesn't like me and has continued to criticize me and defame me unjustly, and as you know, on his blog and I guess in other media has indicated that he wishes to dethrone me, to destroy me. He's indicated he wants to expose me, whatever that means in his parlance, and blow me out of the water. He's also sent me, as recently as a few months ago, scrawled envelopes that say, "I'm going to follow you to the gates of hell," signed his name with his return address on it, sending it to me as a private citizen, not as the defendant in this lawsuit, appended to the top. Sent me correspondence like that repeatedly over the years between 2006 and now.
That personal animus originated with your office's handling of the charges against Mr. Labar, who caused his daughter's death.
I don't know where the personal animus originated in. I know that he's unhappy with the fact that Mr. Labar wasn't charged with murder 3.
Had he ever made any criticisms of you before that case?
No, not before the case.
All right. So his criticism started with the handling by your office of the criminal prosecution of Robert
I
Labar.
would agree with that, yes.
Right. And as a consequence of that handling, he continued to follow up on other DUI, well, whatever term it is that you use,
I understand.
homicide by vehicle while DUI. He followed up on other homicide by vehicle DUI cases and criticized your handling and your office's handling of those, correct?
No, that's not correct as you stated it, Mr. Shea. What he followed up on were other vehicular crashes or accidents in which death was the result, and criticized me and my colleagues in the DA's office for not charging homicide by vehicle while DUI, specifically in connection with the case involving Amber Washko, the case involving Jennifer Geringer, I believe is her first name, and well, those were 2 cases that we didn't charge homicide by vehicle while DUI. He criticized the Labar case for not charging murder 3, criticized the Squires case for withdrawing the charge of homicide by vehicle while DUI.
All those other cases you described were all cases after the cases involving Mr. Labar.
Yes.
So,
Well, with this qualification, Mr. Lauer had a series of DUI convictions in the past, some of which preceded, I think, the crash involving Sheena Villa.
right. And his criticism, the focus of his criticism in the WAEB interviews was the furlough granted Mr. Lauer to attend a wedding, correct?
And the fact that Mr. Lauer had subsequently, in January of 2014, been involved in yet another DUI-related accident on Tillman Street, in the vicinity of 21st Street.
Right. But his criticisms of the Lauer case were all after the case involving Mr. Labar.
Correct.
So isn't it fair to say that this personal animus that you referred to in your complaint toward you began with your office's handling of the Labar prosecution?
That's fair to say.
Now, with regard to the Chris Squires case, did you have any personal involvement in that?
Well, I had conversation with the Chief Deputy District Attorney, Renee Smith, who was handling that case, yes. If that constitutes involvement.
And how about the Amber Washko case? Did you have any personal involvement in that case?
Yes, in that case I had a conversation with the Deputy District Attorney, Paul Bernardino, who was prosecuting that case.
And how about the Jennifer Geringer case?
Yes.
Any personal involvement with that?
Same basis. I mean, in each of those cases, Mr. Shea, and again, I'm not waiving the Criminal History Record Information Act in responding to this. Obviously, when it comes to a charging decision in a significant case, and I would say that in virtually every case in which we charge homicide by vehicle or homicide by vehicle while DUI, I have some, quote, involvement, close quote, in determining what charges should be brought.
And how about the James Lauer wedding furlough? Did you have any personal involvement in that?
I had absolutely no personal involvement in that, although my office did, and I only learned that retrospectively when Mr. Villa raised the issue.
So your office did have involvement in that?
The involvement was that my office did not object to the grant of a furlough 3 days before Mr. Lauer was to be paroled.
And correct me if I'm wrong, I thought I heard you say earlier that at the time that furlough was granted, there was another DUI charge against Mr. Lauer pending?
No, it wasn't pending. It occurred years after the furlough was granted.
Okay, all right, that's
The
what-
furlough was granted, as I recall, in 2011. The next involvement that Mr. Lauer had in connection with the DUI prosecution was in January of 2014.
And that was at or about the time of the beginning of Mr. Villa's interviews with WAEB.
It was about a month before.
Right. And the fact of the furlough, that was a correct statement by Mr. Villa, correct?
The fact that a furlough was granted, which was granted by Judge Dantos, yeah, that's a correct statement.
Okay. And I think you've indicated your office would have had involvement in deciding whether or not to object to that furlough.
Mr. Shea, Mr. Lauer's attorney was Leighton Cohen. He filed a petition requesting a furlough. A copy of that petition was served on my office and on Judge Dantos. Obviously, my office raised no objection to the granting of that furlough.
Right. So Mr. Villa was correct when he stated that your office did not object to that furlough.
He never stated that.
What did he state?
He stated that Jim Martin granted Mr. Lauer a furlough. I have no power or authority to grant a furlough. Obviously, I didn't do that.
Right, but your office did have, and you did have, and members of your office did have authority to object to that furlough.
We could have raised an objection, yeah.
And your office didn't.
Correct.
Now, in your complaint, you describe specific broadcasts on WAEB in which you claim that my client made defamatory statements. Now, looking at paragraph 24A, what was said during that broadcast that was defamatory and done with malice?
Well, just objection in that, I mean, these are all written down in the complaint. I mean, the complaint speaks for itself.
Let's go off the record. I was anticipating that objection.
The time is now approximately 12:43 p.m. We are now going off. The time is now approximately 12:44 p.m. We are now going back on the record.
Mr. Bart, your complaint contains excerpts from broadcasts of the WAE interviews of my client, correct?
Correct.
And you've already indicated that you heard those interviews at the time they were conducted, correct?
Correct.
So in addition to these excerpts, you've heard the entire interviews.
I don't know that I heard the entire interview of every interview. I heard substantial parts of it.
Right. Have you reviewed the transcripts from those hearings after you listened to them?
I'm sure I did at one time. I haven't done so in a number of years.
When was the last time you reviewed
I
the
don't recall.
transcripts? How many times have you reviewed the transcripts?
I don't recall.
Have you reviewed the transcripts of the WAEB interviews in preparation for your deposition today?
No.
Did you review the deposition transcripts from my client's depositions in preparation for your deposition today?
No. I reviewed them sometime consistent with when his deposition was taken, but that was 2015, I think.
Right. Let's look at paragraph 24A.
Mm-hmm.
In that paragraph, what was said that you believe to be defamatory and with actual malice.
So just to be clear, you just basically want him to read for the record?
No, I don't want him to read for record. I'm asking to tell me from that excerpt what was defamatory.
Everything that's in it.
Okay, be more specific, please. What was said that was defamatory?
I've learned the ways that Lehigh County DA Jim Martin fixes these cases. I've learned finally 7 different ways. Bobby Gunther Walsh responds as indicated in the complaint. Mr. Villa says, quote, fixes the cases. I've learned, next paragraph, I've learned it's a growing number of ways now that DA Jim Martin fixes DUI homicide cases for connected cronies. I'm quoting from the complaint, Mr. Shea, just so that's clear for the record. As I said, I see it as case fixing. If it's not case fixing, he certainly leaves himself wide open to that by the stuff he does and doesn't do, not collecting evidence, concealing evidence. Okay, what's the next one, says Mr. Walsh? Villa, lying to the grieving family that Lehigh Valley Hospital screwed up the paperwork on the chain of custody having to do with the blood evidence, and also lying to judges that we have a plea deal that both sides are on board with. Walsh says, I'm asking you to repeat these 3 allegations. Mr. Villa, okay, not collecting evidence, concealing evidence. Walsh says, what line? Villa says, blaming Lehigh County Hospital, there's no such thing, and then lying to a judge. I believe all those are defamatory, particularly when he accuses me of lying. As I recall, that's defamation per se. When he accuses a district attorney of fixing cases, that's defamatory to the extreme, in my opinion.
Now, in that interview, what facts did he misstate other than what you've listed in your complaint and now have read? What facts did he state in support of those claims that were false?
Mr. Villa has no facts that he can state that would prove that I ever lied to a judge or lied or concealed evidence or lied to a grieving family or fixed cases. There's no fact that he could rely upon.
Okay, but he did recite facts during the interviews, and I'm asking you which of those facts were false and done with actual malice.
I'm sorry, and what?
I'm sorry.
Done with actual malice.
Well, let me just clarify. I mean, are you asking him to recite the facts that are printed on the complaint, or the facts that were in the interviews, which are in the transcripts, which he said he hasn't reviewed in a while?
Well, I'm basing it on his recollection. He listened to them, he has reviewed them, and Mr. Villa makes a whole lot of factual claims during those interviews, and I want to find out from Mr. Martin, in this particular interview, what was actionable defamation under New York Times versus Sullivan.
No, objection. Now, listen, he just
Let's go off the record.
The time is now approximately 12:50 p.m. We are now going off the record.